here, Judge. And I think that matters, Judge, in the context of this kind of case. In any homicide case, obviously, there's a victim who's deceased. The difference, though, is we all walk together and we're a little less protected than we would have been with Trooper Edenhofer and the rest, frankly, of law enforcement. Judge, I'm not going to go into too many of the facts in this case. I know that some of the speakers have addressed the facts. I know the court has the state's sentencing memorandum, and I know the court has been on this case for quite some time, Judge. So I'm not going to belabor the tragic facts of this case, Judge, other than to say that this was a tragic, senseless kind of act of violence, Judge. Trooper Edenhofer is no longer with us. He's deceased. 2 other troopers were victims in this case. 1 was shot and survived. What I'd like to focus on, Judge, are the stipulations in the plea agreement. In terms of the 2018 case, Judge, and we all kind of know here, most of us do in the courtroom, that we're really talking about one series of events that happened on the same day, July 25th, 2018, even though there are 2 separate cause numbers. The count 1, amended count 1, the second-degree murder count that Mr. King pled to, the state's asking that the court sentence Mr. King to 25 calendar years in the Department of Corrections. Count 1 in the 2024 case, which is the aggravated assault case, Judge, and that's an F2 dangerous felony, as the court knows. The state is asking the court to sentence Mr. King to 10.5 years in the Arizona Department of Corrections, and asking the court to follow the stipulations that sentence run consecutive to the 25 calendar years for amendment count 1 in the 2018 cause number. I'd like to just talk briefly, Judge, about the aggravating factors for the record. As the court knows, the 25 calendar years on the second degree, or for the second degree murder sentence, is an aggravated sentence. In fact, it's the maximum sentence in Arizona for a second degree murder. I'd just like to point out some of those aggravating factors and the state's thoughts about them. They are listed in the state's sentencing memorandum, so I know they are part of the record, Judge, but I'm going to do this orally as well. The infliction or threatened infliction of serious physical injury, Judge, is an aggravating factor that the state believes the court should consider, and that's to Trooper Edenhofer, Trooper Doris, and Trooper Roadcap, Judge. The use or threatened use of a deadly weapon, Judge, that's very clear here. Even though Mr. King didn't initially possess the weapon, he ended up with it, and he fired the shots that killed Trooper Edenhofer and wounded a second trooper. The third aggravating factor, Judge, is the emotional, financial, and physical harm to the next of kin, or Trooper Edenhofer's immediate family and the other victims. I think those apply across the board to the victims in both counts, Judge. I'm not going to belabor, what you've heard today from the next of kin and from other victims and from personnel from DPS, Judge, but it's clear that, there's a lot of heartbreak here. This is a horrific event, and like a lot of other speakers said, has affected Trooper Edenhofer's biological family as well as his extended family in a clearly tremendous way, Judge. There's also financial considerations here, Judge. Those may be more minor, but they are present. And then the physical issues with the injuries to the second trooper, Judge, are all aggravating factors. One thing and those are statutory aggravating factors, Judge, and I know the court knows that, and we do have them listed. When I say we, the state does. There is at least one important case law aggravating factor, Judge, that the state would like to point out to the court. It's the aggravating factor that there were multiple victims here, Judge. I don't think that's in dispute. but I do think that that's a very important factor here. We have one deceased victim, a second wounded victim, judge, or shot victim. I'd like the court to put weight on the fact that there were multiple victims in this case, Judge. It's a prosecutor's job to try to find justice, Judge. And as I noted when I started this out, and I believe if Mr. Nowhere was here, he would agree with me, we don't believe that we've completely found justice in this case. We did do the best we could. There is mitigation in this case, Judge. I know the court's aware of it. It's in the state sentencing memorandum. I just like to point it out to be fair to the case. Mr. King clearly has mental health issues, and Mr. King did not have a criminal history, Judge. There may be other ones, but those are the two that I'd like to point out to the court, Judge. In terms of the balancing act that the court has to do with the aggravating and mitigating factors, Judge, at least from the state's perspective, the aggravating factors far, far outweigh the mitigating factors for the second-degree murder conviction, Judge, and they warrant the sentence of 25 calendar years in prison. In terms of the sentence for the aggravated assault F2 dangerous, that's a presumptive sentence of 10.5 years. So I'll let the court do what it needs to do in terms of aggravation and mitigation to find the proper balance there. Again, at the end of the day, Judge, this case was super hard on a lot of people. The justice here is not complete, but it's the state's hope that it does provide some closure to the next of kin, to the victims, to the Arizona Department of Public Safety, and to law enforcement in general. So the state would ask the court to follow those stipulations, to follow the recommendations in its written recommendation, and impose those two sentences. There are a couple of housekeeping matters, Judge, that I'd like to put on the record. One is restitution. There is going to be a request for restitution. I know this is a 2018 case, Judge. It's a very old case. I know everybody is acutely aware of that. But the state doesn't have all the documentation of the restitution, so the state is asking the court to retain jurisdiction over the restitution. The other housekeeping matter, Judge, is, and I know that the court had said we will deal with that later, which is fine. There are lifetime injunctions, Judge, that the court will need to deal with after defense counsel has his opportunity to speak, and members of Mr. King's family speak as well. That's all I have, Judge. Thank you.
Okay, thank you, Mr. Chief. Mr. Gromsky, on behalf of Mr. King.
Yes, Your Honor.
I think it depends on how much you guys, anybody speaking?
I will be speaking. I'll probably take up a little bit of time. It's up to you. I just want to take notice.
It's, we'll do this. We're going to keep going, but if people need to use the restroom, you can get up and go and come back. It's okay if you want to do that. But I don't want to make everybody come out, go back in. So you can go forward. But if anybody needs to take a break, go ahead and come out and come back in.
Good afternoon, Your Honor. We asked you to follow the terms of the plea agreement, and you give Mr. King the time that he served in custody at this point. As the court's well aware, this isn't my case. I was brought in this case after the previous defense team withdrew from this case. My part of this case is very limited. It was only limited in scope for the motion to withdraw from the plea offer. So I will let Mr. Apfel speak on their mitigation. My comments will be based off what I observed and my team observed for the short amount of months that we've been on this case. We did find that there are mitigating factors that the court can consider in this case. First, Mr. King's age. He's a very young man. As Mr. Giaquinto mentioned, that this is the first time before the court. So this is his first case and first felony. There are the three other substantial mitigating factors I think the court can find. The first is he does have a strong family support. He does have his mother who lives here as well as his family back in Ohio. They do love him. They did work with defense counsel. I know his mother made it to every hearing that I was present at, so I do think the court can find that he does have a strong family support. In addition, as Mr. Giaquinto mentioned, he does have substantial mitigation of mental health. He does have substantial mental health problems, and I believe that's the reason why the plea offer was given the way it was. The state does recognize that he does suffer from issues that are not his fault. The last is remorse. While speaking with Mr. King, he does have remorse for what has happened. It's hard for him to express it and probably show the emotion that people want to see, but I think that's a factor because of his mental health. So those are the mitigating factors that I observed being on the case. I know Mr. Apfel will speak and have his own presentation that's separate from my own, but we do ask you to find those 5 mitigating factors, Your Honor.
Okay, thank you. Mr. Apfel?
Thank you, Your Honor. This is a sad day, and I thought a lot about what I wanted to say because this case has been a part of my life for 7 years. I was first met Isaac in the hospital just hours after this happened, and when I was thinking about the past 7 years, I was thinking about all the things in my own life that have changed over the course of the time that I've known Isaac, whether it's getting married, having a child, starting my own firm, going through different tragedies. And as I thought about that, I was really overcome by a pretty profound sadness. And the sadness that hit me was because I realized that all those things that I went through in the last 7 years are things that Trooper Edenhofer's family has not gotten to experience with him, and things that Isaac and his family have not gotten to experience with each other. So it's tremendously sad on both sides. And I think that that's sometimes lost, and certainly it's not lost on me. Trooper Edenhofer's family has my deepest sympathy for everything that they're going through. Nothing that I say here today in any way diminishes their suffering, and nothing in any way I say here today in any way is meant to upset that balance. I do view him as a true innocent. He did not deserve what happened here in any way, shape, or form. And what I am going to say about the facts momentarily does not change that at all. As you can probably tell, there is a level of emotionality for me in this case. And I think this is true for troopers as well. It's true for the court. It's true for us as defense attorneys, and it's true for prosecutors. We deal with the worst human tragedy every single day. And in dealing with that, it's necessary for us to create a little bit of emotional distance with the cases that we deal with. Because if we don't, it would be difficult to maintain our own sanity. But sometimes you have a case that just touches you on a personal level. And this has certainly been that case, and it's not just because of the time that this case has been with me. There are a number of reasons that I'll talk about in a little bit. I do want to talk about the facts of what happened, and I want to start off by noting that I think Trooper Doris really hit on the head a lot of what I wanted to say. This never needed to happen. Now, I think our view of how it came to happen may be different, but I think that's absolutely correct. This was a tragedy that so easily could have been avoided. This was a young man who was in the middle of a psychotic break. He was looking for help. The reason he was on that highway throwing rocks on cars was because he wanted the police to come and get him, because he wanted help. He was hearing voices. He's crying out for help. And that in and of itself is tremendously sad. And to his great credit, in my view, I think Trooper Doris was doing the right thing. I think he was talking to him. He was trying to get him into a safe place. This went wrong when it got physical. And it was not initiated by Mr. Kim. The physicality was not initiated by Mr. Kim. This became a tragedy because a trainer had an unapproved holster and a gun that was subject to a recall because it fired accidentally on being jostled. That's what happened in this case. The notion that Mr. King in any way, shape, or form acted intentionally, there's just no evidence to support it. And it saddens me that to hear people talking about Isaac in the sense of somebody who committed some kind of intentional act to take away a life. That's not who Isaac is. It's just not. I've gotten to know him over the course of 7 years. I've gotten to know him pretty well. This is a young man that doesn't have a dishonest bone in his body. He hates lying with a passion. I've never even seen a trace of violence in this young man. He was a young man that needed help, and things just didn't go the right way. I understand that a lot of people want to hear him get up and speak and express remorse. I want this court to know that he wants to do that. I advised him against it, in part because I do believe that there will be post-conviction relief proceedings, and I do believe that there is a reasonable possibility that those proceedings could be successful. I'm disappointed that the Legal Defender's Office didn't come here today to support him, especially given the fact that they were here with him for 6.5 years. I think it speaks volumes. But for Isaac, to the extent that he can, understands the gravity of what happened in this case. He has a great deal of sadness. He certainly has remorse that things turned out the way they did. It was never for a moment his intention for anybody to get hurt. He was a young man that needed and wanted help. This is why I think you're seeing in police departments and agencies across the country this move towards having social workers as part of their departments in order to help people that are in Isaac's situation and to avoid these types of situations escalating to a point where something like this might occur. Had that been the case back in 2018, maybe we wouldn't be here today. Maybe it would have been a minor case and nobody would have to suffer what they've had to suffer through today. He does accept his responsibility in that respect. He deeply regrets that his search for help and the way he went about trying to get help wound up putting him in the situation that he's in. So with all of that said, I also don't believe that this is a just result. Now, not surprisingly, my reasons are significantly different. I don't believe that this young man deserves this type of length of prison sentence. If we were going to look at the true legal nature of his actions, I think that they would amount to a manslaughter because he created a set of circumstances that were dangerous. But I don't see any intentionality in his acts. And frankly, I think that this 35.5-year sentence is grossly excessive. Now, I know we had a hearing where we discussed a great deal of what we said and what we didn't say. And I expressed the fact that I've never said that to him before. This is the first time Isaac or his family have ever heard me say that, because I didn't want to express my true feelings about the plea, because I didn't want to mislead him into doing something that, maybe he did want to do or didn't want to do. I wanted it to be his choice. And I certainly don't want to open wounds by discussing some of the facts of the case. It's something that I try very hard to avoid to do, because the last thing that I ever want to do is upset people who I believe to be legitimate and innocent victims. But there are a lot of things that have been said about this case and about Isaac that just paint a false picture. And I think in fairness to him, in fairness to his family, who have desperately wanted over the course of the last 7 years to talk about some of these facts, it needs to be said. And it needs to be said what kind of person Isaac really is.
Now, I agree with you, the second part, but I don't agree that this is the forum to argue about facts, especially with a plea and come close to attacking the factual basis. We're not going there. So I'm not, to the extent you want to go into analysis of the facts, we're not going there.
No, I've said what I had to say
Okay,
in terms of
thank
the
you.
facts.
Go ahead.
There were just a few things that I think needed to be put on the record, in part because of things that have been
Okay,
said today.
you did it. Go ahead.
And, in part because part of my obligation is to represent my client and his interests and to make sure that everything is put forth clearly in terms of what happened. And again, it's not intended to upset anybody, but sometimes part of what a defense attorney has to do is make sure that things are clearly
And
said.
there are appropriate forms for that. Sometimes sentencing not. But go ahead.
Understood, but I didn't have the opportunity in any forum to say that, neither did his family. So, having said that, again, it is my belief that this is not an appropriate resolution.
Heard it the first time.
I understand that the court is going to accept the plea and is going to move forward. However, we do encourage the court not to do that, because I know my client does still feel that he was pressured into the plea. So having said that, we're asking the court not to accept the plea and to reject it and allow Isaac to go to trial.
Okay, thank you. Mr. King, is there anything you want to tell me before I close sentence? Okay. All right. So let me start with this. For Tyler's family, friends, colleagues, and Trooper Doris and Trooper Roadcap, the thing I want to communicate most is I'm sorry. I'm just so sorry that this happened. I can't go back and do what I want to do, which is go back and make it July 24th, 2018, that would be something I wish I could do, and I can't. And I am very sorry, not only that this happened, it happened to Tyler, it happened to the other troopers, and the tremendous loss for the family, for the community, that I can't even begin to fathom, so I won't pretend that I can. But I'm also sorry that this was one of those cases that took so very long to resolve. And the pain associated with that long time to resolution has to be overwhelming. I want you all to know, though, that time frame was not because anybody was doing anything wrong or that they weren't doing their duty, whether it was the prosecutors or the defense lawyers. And it wasn't because Mr. King was doing something wrong or that he wasn't entitled to do. It was just the circumstances of this case. But I know that increased the pain, and it makes it so much harder now to come back 7 years later to relive it, to get some finality. I will not say that there's going to be closure because I don't think there ever is. But my hope for all of you is that today is a step, an important step going forward. That today will help you move on in a way that can help you and your family to be or get a little bit more peace. Peace that I know won't entirely ever come, but that hopefully can make things a little bit better going forward. I want to express my respect for all the first responders and what they did. And people have basically talked about it. This was a call that, in the nature of calls I know, probably nobody could have fathomed would be anything other than a pretty minor situation. Yet here we are. And that's what law enforcement deals with every day, that you never know who you're pulling over, what's going to happen. And I respect the pain that goes with the loss and for law enforcement for basically what they do. I want to address the plea and whether it's appropriate or not. When I issue a sentence, even if it agrees to what it is, the law tells me that I have to identify and consider what are called aggravating and mitigating circumstances, no matter what. I don't just say, okay, I accept the sentence, because if I don't think legally it's appropriate, I need to reject it. And so I consider the aggravating and mitigating circumstances, and then typically if they balance, then what's called the presumptive sentence is appropriate. If there are aggravating circumstances that outweigh the mitigating circumstances, then a aggravated sentence is appropriate. And if the mitigating circumstances outweigh the aggravating circumstances, then usually a lesser sentence. Here, I have to go through that exercise even though there's a stipulation or agreement. Mr. Giaquinto referenced it, and I largely agree with the aggravating and mitigating circumstances that both Mr. Giaquinto and Mr. Gronsky identified. Let's talk about the aggravating circumstances. First of all, I do agree that the overwhelming and most significant aggravating circumstance is the harm to the victims. It's the harm, obviously, that was caused to Trooper Edenhofer and his family, to Trooper Doris, to Trooper Roadcat. And I do think that, to be clear legally, the harm to the victims extend a little more extensively to the second-degree murder case, such that the aggravated sentence is appropriate and has less of an impact in the aggravated assault, hence a presumptive sentence is appropriate. I also agree with the state that the aggravating circumstances of infliction of or threatened infliction of serious physical injury and use of a deadly weapon also apply here, and the multiple victims, I agree with that as well. Those are significant aggravating circumstances. But I also don't want it to be lost that there are mitigating circumstances, and I don't want it to be lost that they exist in this case, and they also tell us something about Mr. King. If I was sitting here, I would not want to hear about anybody, about the defendant mitigating circumstances, because a life was unnecessarily, unreasonably taken. But I will say there are significant mitigating circumstances here. First of all, Mr. King undoubtedly has mental health challenges, mental health concerns that are documented and they're significant. From the court's perspective, it is very clear that Mr. King was going through a mental health episode at the time that this happened. It may have been exacerbated potentially by substance use. Either way, I do know that it's very clear that he was going through significant mental health issues. And the reason I say that is this person's history suggests nothing about a violent history. He's got no prior felony convictions. He's got no prior misdemeanor convictions. And I will tell you, reading the letters from his family and from educators, they talk of someone that is exactly the opposite of the result that happened here. And I want people to understand that, because that's not who Mr. King was going into this. It's not. And people, I think we need to acknowledge that that's the case. He was very young when this happened. That's a mitigating circumstance from the court's perspective. And he's got family support. That's a mitigating circumstance. I do think, although it's a little bit different than usual, he accepted responsibility when he entered into the plea. I understand that he requested to withdraw from the plea. When I put all those together, from the court's perspective, the stipulated sentence is appropriate. There is no justice here for anyone in the courtroom. There's none. There can be no justice for Tyler and his family. There just can't. And I'm sorry for that. But what there is, as best as we can as a society, to come to a result, as just a result as we can find when there is no clear-cut just result, because that's how life is. This conclusion, this result under the law, in this court's view, is appropriate. And therefore, I do believe that the stipulations are appropriate. I'm going to accept them, and that's how I'm going to sentence going forward. So we're going to talk about what the details of the sentence are. And we're going to start with the 2018 case. And I have counsel make sure you check me on my numbers in terms of credit, etc. In that case, I'm sentencing you to a term of 25 calendar years in the Department of Corrections to begin from today's date. I've got credit for 2,574 days of time served as of today. This sentence is to run consecutively to the next sentence that I'm going to impose. I'm ordering community supervision, and I'm ordering restitution. We heard Mr. Giaquinto reference leaving restitution open. I'm going to do that. I think the law is pretty clear. It can remain open for an extended period of time. Mr. Gronsky does. Mr. King wanted to be present for any restitution here.
He does not, Your Honor, and he uses line.
Okay, thank you. I'm going to leave it open. I'm going to indicate 24 months. The state actually asked for 12 months in the sentencing memorandum. I'm going to leave it open for 24 months. And then if there is a disagreement, then it can be resolved by the court as to the restitution going forward. So I talked about there are multiple requests for what's called a lifetime injunction. It's really important to remember what that is. A lifetime injunction prohibits a defendant or anyone acting in on the defendant's behalf of having direct or indirect contact with the person holding the lifetime injunction. So I'm signing all of those, and that will go into the record. Just so Mr. King knows, and I'm very confident that Mr. King would never violate the injunction, but make sure you have no contact with any of the victims and don't try and contact them, or anyone does that for you or on your behalf. And as I said, I will review those and sign those at the conclusion of the hearing once we have finished. In the 2024 matter,
Sorry, Your Honor, while you're doing that, just in terms of the number of days, I have 2,577. I think they forgot to include the 2 leap years, as well as the fact that he was in the hospital on the 25th in custody.
let me take a look at let me see how they calculated, if I can see what their methodology was. So I see them starting in the 2018. I've got it actually, it looks like they started 7/29. They should have started 7/24.
725.
Okay, so that's +4.
Correct. And then there's the 2 leap years in 20 and 24.
You think so? It's 2
extra days.
So 6 extra days. We're going to do our own independent one, and we'll get to that. But I agree with you that there's 4 additional days for sure. So I'm going to change that. Hold on. July 26. calculating that in the 2024 matter, I'm sentencing you to a term of 10.5 years in the Department of Corrections to be served consecutively to the 2018 sentence. Because it's consecutive, there is no credit for time served. I am ordering community supervision as well. I'll leave restitution, the same thing, open in that case for up to 24 months and indicate that he's waiving his presence. Hang on for a second. So our calculation's a little bit different. We've got 2,576. I think it's in part, I think we'll figure it out to the day. I think it's 2,578, so we'll work through that. As I said, restitution's being left open for up to 2 years in both matters, and there's no credit on the 2024 case. Mr. Giaquinto, do you have the forms, the lifetime injunction?
Yes, I do.
Okay, why don't you go ahead and approach? And while you're approaching, think about if there's anything else from your perspective with respect to sentencing that we may have missed and not covered.
Just for the record, no objection to the.
Thank you. Thank you. Mr. Giaquinto, anything else from your perspective?
No, Your Honor, not from the state.
Okay, Mr. Apfel, Mr. Gronsky, anything else from your perspective?
No.
Okay. All right. So I have to read you the applicable rights that apply. You have the right to petition for post-conviction relief from the orders of the court and to have a lawyer represent you. If you cannot afford a lawyer, one will be appointed for you. If you cannot afford a certified copy of the necessary records and transcripts, they will also be provided to you at no cost. If you want to petition for post-conviction relief, you must file a notice within 90 days from today, or you lose the right to seek relief. You also have the right to file a petition asking for the court to set aside any judgment of conviction, to seal all case records and restore rights, but you may or may not qualify for that relief, and you have to file a petition asking for that relief. You must sign a copy of your rights to review, and you must also give the court a fingerprint. On motion of the state, the matter set forth in the plea agreement for dismissal or dismissed, any bond is exonerated, and you are remanded to begin your term. Good luck to you going forward. And good luck to all of you going forward. I wish the best for everyone here. So what I'd like to do is invite this side to go first. Mr. Gronsky, yes?
Yes, Your Honor, at this point, we ask to withdraw. For my limited scope, I believe I am done. Mr. Apfel can go ahead and handle the restitution, but I believe it would be appropriate for me to be withdrawn at this point.
There's an oral motion to withdraw, and I'm granting that oral motion to withdraw. Mr. Apfel remains.
Yes, and I agree. And with any restitution requests, if I'm not going to handle it, I'll just let the court know to go ahead and appoint counsel.
Okay. All right. So for all of you, best wishes going forward. You are free to go now. I'll ask this side to stay for a little bit. I got paperwork I've got to do. Mr. King's going to be here for a few minutes while I'm doing the paperwork.
I already told him.
All right. Thank you, everyone, for your time.